really a pleasure to be here. It's a bit daunting to speak in front of so many people. Very few cameras are on. I don't know whether this is on purpose or whether people are hiding or not there. I would appreciate to be able to see someone, but if you have a reason not to switch it on, it's fine. It's just that I'm looking at myself and a lot of a lot of black screens. Thank you so much. So I understand you've had a very busy 4 days already, with a lot of content, a lot of discussions. I was asked to speak on unilateral measures, and I'll be very happy to do so. There's a lot of technical detail, and a lot is happening on this here in Europe. I'm very keen to share my views on this and some of the details, but I also fear that doing this online may be a bit difficult. So I would really appreciate if you just raise your hand if you have a question, if I'm going too slowly, too fast, if something is unclear, because otherwise it gets a bit strenuous for me as well. So I've prepared a PowerPoint, and of course I will share this with you. I hope you can all see it. Yeah, it's
Sí, perfecto, just.
Okay, very good. So I know this is the end of your week, and you've been talking about a lot of trade and sustainability initiatives topics. What I was tasked to do is to talk about unilateral mechanisms, and Veronica mentioned it already. It's increasingly difficult for countries to agree to converge on their environmental policies. And especially the European Union, but also the US and some other countries, have taken unilateral initiatives, I think with good intentions, to deal with climate change, biodiversity, deforestation. But in many other countries, and I think Brazil is a prime, what word can I use? A prime victim of this, a prime target of this. In many countries, this will hit hard. And one of the reasons I was really quite enthusiastic to do this is to share the perspective of the EU on this, and to also hear from you what you think about all of these measures, because I do think they are important, but they will hit Brazilian steel, soybean exports really hard. And unless you seriously get into this as a government, as traders, perhaps challenge some of these measures or try to influence the EU Commission to tweak the details. So I'll talk about this idea of unilateral initiatives. Then we'll go through two examples: the CBAM and the EU Deforestation Regulation. And then at the very end, but I will keep this very brief, I can say a few words about how other countries have reacted to this, or how other countries have taken similar or different initiatives. Okay. Are there any questions at this stage about things that I may be missing, things you want me to cover? So if you want to say something, you can raise your hand electronically, and then I can see it. I don't see all of you. I don't think any of you are raising hands. It would have been, we don't have the time, but it would have been.
Estoy viéndolos, pero no veo ninguna mano levantada acá.
It would have been wonderful for
all
me
participants, but not any raised hands so far.
Okay. Okay. Good. I mean, ideally, it would be wonderful to see everyone introduced, but we don't have time for this. I'm just assuming that there's a lot of people from Brazil, but perhaps also from other countries. But I will be talking or using Brazil as my example. So I'd be, again, very keen to hear your perspectives. Okay. So what we'll discuss is what many people call unilateral mechanisms. So Veronica mentioned it. My background is law. I'm a law professor, a lawyer, an arbitrator. Words mean a lot in my profession, and perhaps for non-lawyers, this is not that crucial. But sometimes when people hear unilateral, they think that there's something wrong with this, or that it is illegal under WTO rules or under some other mechanism. So the way I understand unilateral is very different from illegal. So when I use the term unilateral, the only thing it means is that, for example, the EU is enacting these mechanisms on its own. The mechanisms I will explain are pieces of EU domestic legislation. They are not agreements. None of this is mutually agreed. Unlike, say, the WTO or the EU-Mercosur Free Trade Agreement, these are things that the EU is doing on its own. It has consulted broadly before enacting these mechanisms, but they are unilateral in the sense that Brazil, Argentina never agreed with those mechanisms. So I'll be focusing on the EU. And if you listen to the EU Commission, their trade policy is relatively clear. They favor the multilateral level, have always done. But since a couple of years with the new Commission, they have kind of given up on doing only multilateral and bilateral. And they've realized, look, the WTO is not going anywhere on many of these issues. We cannot move fast enough. So we will have to enact what they call autonomous instruments, or what your organizers have called unilateral mechanisms. And those autonomous instruments are new. The EU never did these kind of things until recently. But as much as I will be talking about EU autonomous instruments, it's very important to know that the EU remains very active at the multilateral level, remain open to discuss all of this. And as you know, is also continues to be a very strong proponent of free trade agreements. And the EU-Mercosur deal, of course, is on the table. And to be honest, this is unlike the United States. The United States has given up the idea of concluding new free trade agreements, and it is pursuing different mechanisms. The EU is really operating at three levels: multilateral, bilateral or regional, and then unilateral. And it's this third level that we will be talking about. Any questions on this? Again, I have no idea about the level of background you have on these issues. If something is unclear or you have a question or comment, let me know. Okay, I don't see any hands. As I mentioned already, one of the reasons why the EU is shifting to unilateral or autonomous measures is this idea of urgency. You know, climate change is happening. We can't wait for another 5 or 10 years. Same with biodiversity. And to reach agreement at the WTO or even bilaterally takes too long. So the EU is saying we have to act now, as much as they would prefer to have collective action. There's such urgency that they decided to act on their own. Okay, so let me turn to the first example, the EU regulation, the EU Deforestation Regulation. Okay, so I'm sure you're all familiar with this, because Brazil is often mentioned when we talk about deforestation. But the EU perspective is that we have to act urgently. In the last 30 years, we've lost forests larger than the size of the European Union, so huge amounts of forests. And deforestation for the EU is a climate change issue. If we have fewer forests, fewer CO2 emissions can be captured. But it's also a biodiversity issue, deforestation. And on top of that, and all of this is mentioned in the regulation, for the EU, deforestation touches on many other issues, ranging from indigenous people's rights to pandemics. A long list of issues that the EU considers linked to deforestation. For the EU, deforestation is important because of agricultural expansion, right? So 90% of global deforestation is because of governments, farmers, ranchers cutting forests to make cropland, livestock grazing land out of it. Which of course raises a big question of, should we keep the forest or should we go for the economic activity? Now, a notion that is key both in the Deforestation Regulation and CBAM is this notion of embedded deforestation or embodied deforestation, embedded emissions. That is, the EU is worried about EU consumption. The EU consuming soybeans, palm oil, maize, importing it from Brazil or Argentina, knowing that these products may come from land that was beforehand forest. And they've put numbers onto this. So you may have a ton of soybeans. If this is coming from deforested land, the EU looks at it as embodied deforestation. The EU considers itself complicit, guilty in this deforestation that has happened. So the EU has focused on a couple of commodities, originally 6, eventually 7, and the numbers are quite staggering. So these 6 commodities alone have an embodied deforestation of 230,000 hectares on average per year. That's a lot of deforestation that happens through EU consumption. And it's this EU consumption that the EU wants to tackle. So that's the background. Now, in terms of the regulation itself, let me go through some critical dates and then see whether there's questions. Both the CBAM and the EUDR are very, very recent. Okay, this is happening as we speak. These texts are very long, very complicated, and I'll be trying to condense it in some basic points. So the EUDR was only adopted last May. Okay. What happens in the EU is that it's only when it's published in the journal that it becomes official. So that was last June. And it's in force as of the end of June. So we are really talking about something very, very recent. The other thing to remember is that, and I don't know whether any of you are in the business of any of these commodities, that you still have time, about 1.5 years, before the main provisions will apply. So all of this will apply as of the end of 2024. And for micro and small undertakings, they will get an extra phase-in period. The other thing to remember is that when the EU talks of deforestation, the cutoff, so when they will check whether something was a forest or not, is end of 2020. And I'll show you in a moment. The idea is that you have satellite images, that you have evidence as to whether the forest is still there or whether it has been deforested. And evidence will be a huge issue in getting your products onto the EU market. The other thing that is interesting is that if you have stock at the moment that was produced before the end of June of this year, the regulation won't apply to this. Timber is an exception. The EU already had timber regulations, had timber rules, and for timber, the old regulation would apply anyhow. Last point in terms of timing, and I've been talking to some Brazilian interests in particular, the details are not out yet. So this is the basic regulation. There'll be a lot of implementing acts, a lot of reviews that are planned before this whole thing kicks in, a lot of decisions that will have to be taken at the Commission level. So if any of what I'm going to explain to you raises questions, serious concerns, there is still time for your countries, I think, to really lobby the Commission, show reasons for why something is unfair or discriminatory for quite some time before the regulation truly kicks in. Any questions? Am I going too fast, too slow? Have you already seen all of this? Is it new?
Tenemos una pregunta de Natalie Iva.
There's a question by Natalie
Natalie,
Iva.
si quisieras abrir tu micrófono.
Yes, I
Natalie,
see in the
would
chat.
you like to open your mic, please?
Ella quiere saber, a ver, cuáles son los 6 commodities que mencionaste.
She would like to know which
Acá,
which
Daniela
are
le
the 6
responde.
commodities you've just mentioned.
Yes,
And
I'm.
Daniela is
Yeah,
providing the answer.
Yeah, so this is in one of my latest slides, but those are the commodities. So what it does is it captures basic commodities, cattle, cacao, coffee, all palm oil, rubber, soya, wood, and then also explicitly listed derivative products. So things that are made with these commodities. Furniture, chocolate, soybean flour, oil. And of course, the idea is that this is the beginning, that perhaps over time, more products will be covered. But like CBAM, the EU starts with the most problematic commodities and then plans to expand it. Okay. So for these commodities and these products, what are the obligations? Okay. It's relatively simple. The regulation says that you cannot market your soybeans from Brazil. There's a prohibition to import them into the EU or for EU farmers to produce any of this or to export these products unless you meet 3 conditions. One is your product has to be deforestation-free, and that's defined. Secondly, you have to comply with Brazilian domestic laws if your soybeans come from Brazil. And it's a long list of Brazilian laws. So it's quite awkward. The EU is imposing compliance with Brazilian law. And then thirdly, as a trader, as an importer, you have to produce a due diligence statement. Okay. Now, this prohibition, this idea of your soybean has to be deforestation free, is implemented through a due diligence obligation. So what you'll have to do as a Brazilian soybean importer and operator is you'll have to show clear evidence, information, data, documents of where the soybeans are coming from. And most importantly, and it goes into a great level of detail, you'll have to show the exact land plot where the soybean was grown and provide geolocation evidence that there wasn't any forest there before the end of 2020. On top of that, you have to have risk assessment measures. There's all kinds of criteria that as an operator you have to go through, including checking compliance with Brazilian law. And then if there's any risk that the product may have come, perhaps from deforested land, you have to enact also risk mitigation measures. Okay, so there's a lot of uncertainty here, a lot of evidentiary issues, a lot of questions as to how precisely can you show that your product is deforestation free. But at this stage, those are the criteria we have. Now, very importantly, and I'm talking mainly to people who know of trade law, GATT, WTO, the EU is imposing this obligation on EU production. So any EU timber, it's not that we make palm oil here. I'm not sure whether we have soybeans, but all of the products made in the EU have to comply with the same obligation. And of course, the obligation also applies to imports. Okay? So those are the obligations. Those are the products. And to bring this to life a bit, if you look at the embedded deforestation in EU importation, you see that palm oil and soy are the prime sources of deforestation. Wood, cacao, coffee, beef, rubber is also covered. Maize is not covered yet. And one of the reasons is it's the smallest contributor, but we are talking mainly about palm oil and soy. And from what I understand, what Brazil is exporting in particular is soy, right, to the EU. So that is covered. Now, very importantly, the extent to which you'll have to comply with due diligence, the difficulty you'll have complying with this regulation will depend on how the EU Commission will classify Brazil or Argentina or any of your countries. And here again, this is a decision that the EU Commission has not taken yet. This will be taken by the end of next year. So there's still a lot of room to lobby, to influence, to explain. At this moment, all countries are default classified as standard risk. And based on certain criteria, the rate of deforestation in Brazil, expansion of agricultural land, production trends in Brazil, also possible cooperation between the EU and Brazil, say through the EU-Mercosur FTA, all of that will determine whether the EU will classify Brazil as high risk, standard risk, or low risk. Now, I can tell you, this will be a hugely important decision. If Brazil is classified as high risk, then the burden on Brazilian exporters will be massively bigger than if it were low risk. Because if you're a low risk country, all of your products will be subject to simplified due diligence. Same is true if you're a small or medium enterprise trader. So, to be honest, I think Brazil has a high chance of being classified as high risk, unless certain big things change. So who knows? If it's classified as low risk, and then of course you have to make sure that everything you import into the EU must be produced in low risk countries. You can't have a batch of soybeans with a bit of soybeans from low risk and then the rest from Brazil or so. But if that's the case, then you only have to comply with the first of the 3 tests that I've mentioned. You only have to collect basic information, share this. You don't have to do a risk assessment, no mitigation. Now, there is a loophole. So NGOs, other interested parties can submit evidence, sharing substantiated concerns with the EU Commission, even for low-risk countries. And if that's the case, if there's substantiated concerns found in low-risk countries, then you have to do a full due diligence anyhow. So the same simplified due diligence will apply for SME traders. Okay. Any questions? Because I've explained the product coverage, the obligation, this idea of country classification.
If I may, I don't know.
Yeah.
Hi, hello. I'm from Argentina. Thank you for your presentation. I have a doubt. No, you mentioned that there are 3 conditions that an importer or a Brazilian or Argentinian exporter will have to comply, in order to be able to export its products to Europe. One is a due diligence statement, another is a deforestation-free statement, and then you have to comply with your domestic law, no? With Argentinian law. And according to our legislation, we have legal and illegal deforestation. So I don't see any coherence for the EU to ask that we have to comply with our law, but they cannot accept that we can export from a region where we're having legal deforestation. We allowed our producers in certain cases to deforestate. So I don't see any coherence with that, no? with that these 2 requirements. They're asking us to be from a deforestation-free area, but they don't accept that we can have, or in certain countries, we have legal and illegal deforestation.
Mm-hmm. Yeah.
So we are with our domestic law. So they should be able to accept our products coming from that particular region.
Yeah. So, I mean, it all sounds very kind of top down, but let me, I had some definitions here. So you have to realize when I say, or when the EU says your product has to be deforestation free, this is deforestation free as the EU defines it, not as Argentina may define it. So deforestation free, as you can see it here, is basically saying it cannot be coming from land that has been deforested after 31st of December 2020.
So they are imposing their law over us.
Yeah. So the EU is giving its own definition of deforestation free. And then the other thing is,
so the second
when I
requirement
say,
should be that we have to comply with the European legislation instead of our own legislation.
no, and of course that's the whole issue with these unilateral mechanisms. It's the EU deciding what is deforestation free. And the EU is not saying Argentina has to change its laws. The EU is just saying that if your product is not deforestation free as we define it, you cannot sell it on the EU market. But yeah, it's a very good point you're making. And then in terms of compliance with domestic law, and to be honest, I don't know what an impact this will have. It's compliance with domestic laws, not just Argentinian laws on forests. Actually, that's not the main thing. It's Argentinian laws on land use rights, environmental protection, labor rights, human rights, tax corruption, trade and customs regulations. So a long list of requirements that are imposed on Argentinian products before they can come in.
If you see item C, for instance, forest-related rules includes forest management, so they should be able to allow the different countries to have their own forest management, as we do. No, we have our own forest management legislation. So in that regard, they should be able to accept when, for our legislation, we have illegal deforestation rules, and also we prohibit illegal deforestation.
Yeah.
But in any case, it's something to discuss perhaps before the WTO.
Absolutely. Yeah. It's a very good point. So you have to comply with Argentinian laws, but on top of that, you have to also comply with what may be a stricter EU law. You're right. Other questions?
Thank you.
Hay una pregunta de María Clara Raiteri.
There's a question by Maria
María
Clara
Clara, si quieres
Raiteri.
abrir el
Maria
micrófono
Clara,
y
would you like
hacer
to
la
open your
pregunta,
microphone, please,
así
and make your
Dios te
question
puede ver.
so that you may see you and answer?
No la veo.
I don't seem to see her.
Bueno,
Okay, but
leo yo la pregunta. No
I
sé
will
si tú,
read
Just,
out
la
her
puedes ver.
question. Can you see that question on the chat, Just?
Entonces,
Yeah. Somehow
dice
not coming
María
up.
Clara, ¿cómo se
Maria
relaciona
Clara
con
says,
el
how is
principio
this
general de
related to the
responsabilidades
general
comunes
principle of common but
diferenciadas,
differentiated
teniendo en cuenta que los
responsibilities,
países de la
having in
Unión
mind that
Europea
EU
y los del
countries and
Mercosur
Mercosur
no se
countries
encuentran en igualdad de
are not on
condiciones
an
y la
equal
Unión
footing,
Europea
and the
está
EU
imponiendo
is
unilateralmente
imposing
exigencias tanto para sus
requirements on a
productores como para
unilateral
los
basis,
productores de
both for
terceros
producers
países, que
and producers of
representan
third
un mayor
countries
esfuerzo
that
para los
account
productores del Mercosur.
for
Por
a
ejemplo,
higher
en
effort for
general son
Mercosur
pequeños y
producers that in
medianos.
general are small and medium producers or SMEs.
Yeah. So that's another very legitimate question, right? So, I mean, the EU has also known massive deforestation, perhaps not in the last 30 years, but in the last 200 years, right? many of our forests here are gone, right? Or replanted or not the original ones. And many emerging countries, you still have to develop, cut forests, what have you. So there's a clear fairness question, right? And at this stage, the EU does not make distinctions between imports from developed countries or imports from developing countries. It's all the same conditions apply. When it comes to SMEs though, SME traders, as I've mentioned, they will get more time before the regulation kicks in, and their due diligence requirement will be simplified, right? But still, this will be costly. It will not be easy to comply with all of these conditions that I've mentioned, okay? So again, a very good point that you've mentioned. Remember, I am originally from Belgium. I'm sitting in Geneva. I'm not here to defend this regulation. I'm just here to explain it to you and really interested in hearing what issues you have problems with. Because like you, I'm also worried about this and how it will impact, whether it will work, to what extent it will impose costs, but perhaps not really achieve much in actual stopping of deforestation. So, yes?
I do have a question regarding the last slide. It is mentioned that for SME traders, they can rely on due diligence done by their suppliers. So I understand that non-SME traders cannot rely on due diligence provided by suppliers. So where does the data should come from?
Yeah, no. It can also, they still have to do their own due diligence, but of course, a lot of the data will come from their suppliers, right? But then they have to incorporate it into their own risk assessment, their own risk mitigation process. So also larger traders can rely on data, due diligence done by suppliers. Actually, to me as well, when I was reading this second bullet, it wasn't very clear what that second bullet really means. And if it's not available, whether even small traders will have to do a complete own full due diligence, which of course will be impossible if they have no data from their suppliers. Again, all of it is at this moment relatively basic, and there's provisions there that need to be elaborated, and I think a clear intention from the EU to make it simpler for SME traders.
Somebody's microphone is open.
Right. So I think with SME traders, small producers, there's a lot of flexibility that will probably be added. But as the other speaker mentioned, in terms of flexibility towards developing countries, or special and differential treatment, common but differentiated responsibility, that is not reflected at all. Okay. So another really important feature of this regulation, because EU law is complicated. As you know, the EU has 27 members. If you ship stuff from Brazil, Argentina to the EU, you actually have to bring it into a specific customs port, and it may be in Rotterdam in the Netherlands, or it may be in Germany or France, and that risks making things easier or more complicated. Because the reality is that the enforcement, this regulation, as a regulation, will have to be implemented in the law of the individual EU member states. And it will also be enforced by the authorities of Belgium, of the Netherlands, of Germany, and by the customs officials of these different countries, not the EU Commission. So another fear, another risk, but perhaps for traders that may be a benefit, is that some customs authorities will be more lenient than others. Perhaps if you ship it through Romania, it will be different than shipping it through Germany. And then there's a lot of detailed provisions on checks, remedial action, corrective action, penalties. And again, those will all have to be imposed by national authorities. And more broadly, there's a lot of push to enforce EU environmental law, even with criminal penalties. So all of this it's very, very serious on a commercial level, but also on a personal business level. If you get it wrong, you may end up in jail. So this is very serious. Those are very serious rules. Now, there's some estimates that were done by a consulting firm advising the EU in terms of the projected cost. Because as some of you already noticed, like this will be a lot of paperwork. You'll have to collect data, you'll have to engage consultants, data firms, and the estimate is that for operators, this will cost, but you can see the range, between 125 million to 1.7 billion euros per year. And of course, low-risk operators will be much easier than high-risk. So for a company per year, this can easily cost 10,000 euros. Member states, as I said, they'll have to have the authorities, the people in place to check all of this. And the estimates are that this will cost EU member states collectively 80 million euros per year. Now, the projected benefits, they are counting on a 45% effectiveness rate, would be to avoid more than 100,000 hectares of annual deforestation. And that because of lower deforestation levels, we would also see a cut in CO2 emissions, which of course, that also has a price, and then improvements to soil, water, air quality, and biodiversity, I guess, in the countries of origin. So there's a very tricky cost-benefit analysis to be made. Now, one of the people asking, I think the second question, that concern for small traders was recently reflected also in a very public statement by the head of the International Trade Center here, which is a WTO UNCTAD organization. And I think it's quite exceptional that she was explicitly very critical of this EU regulation, saying that especially small companies will have a really hard time tracing where their products are grown, and as a result, they may have a hard time getting their products into the EU. Okay, and here I will share all of this, but I think this is crucial to look carefully at what is a forest, what do they mean with deforestation, forest degradation, and then how do we, the EU, define deforestation-free? And that's again the list of laws that you'll have to comply with before you get your product in the EU. Any questions on deforestation? Because that was my first example. Is this a topic that has been discussed a lot in Brazil, Argentina?
Yes. I do have a question. The EU mentions that they pretend to maybe expand the regulation for other wooded lands and also maybe other products. And yesterday we were seeing a presentation regarding the CBAM, and the EU has a list on potential carbon leakage products. So do they have a list on potential deforestation products? So maybe we could take a look and think, well, these are potential products and other wooded lands as well.
Yeah. I'm sure that it must be available somewhere. In terms of more commodities, maize is the one commodity that is not covered yet, but that, yeah, most likely will be covered in the near future. But it's a good question. If you're a trader, you want to know beforehand what could be covered, what not. I'm sure there must be documents out there that may guide you.
Okay.
Other questions?
Tenemos una pregunta de Luciana Paladino. Ahí
Yes,
está.
we do have a
Adelante,
question
Luciana.
by Luciana Paladino. Luciana, you
Yeah.
have the floor.
Hello. I understood you said that the EU feels it is an accomplice of the deforestation as a consumer. And it's one of the reasons for this law, because it felt it needed to do something about the problem. But then you said the cost, it will be set on the rest of the world, at least the majority of it. So is that correct? Is that what you said?
Yeah. I think the reality, it's a very good point. Huh? So this will cost money for companies. To me, and I'm not an economist, but as you were implying already, the real question will be to what extent will you be able to shift that extra cost into final consumer prices in the EU? And I think some of it will probably go into higher prices for soybeans, for oil in the EU, because producers will be able to charge consumers more. Now, if there's competition, if it's difficult to shift forward these extra costs, some of them will have to be borne by the producers. And I think that's exactly the fear, especially for smaller producers, that extra cost, they won't be able to cover it, and they won't be able to export to the EU anymore. And it's a very fair point you're making, that if the EU is worried about deforestation abroad, perhaps they should also contribute to fighting it.
Exactly.
Yeah.
It doesn't seem very collaborative, this way of acting.
Right. Now, as I mentioned in the beginning, so the EU is talking with Mercosur and the free trade agreement. There's other mechanisms where the EU is financing certain projects. I don't have details on this, but I'm pretty sure that you need to look at this regulation in the context of other initiatives where the EU is perhaps supporting, providing funding to meet the costs of this regulation. But it's a very fair point that, yeah, perhaps the EU wants to do this, but then the EU will have to help producers in Brazil do so and bear some of the costs, be it the EU consumer or EU authorities through financing. And it's exactly the same problem with CBAM, with CO2 emissions.
Exactly. We've seen that yesterday, I think.
Yeah. Okay. So, Veronica, you tell me whether CBAM has been completely covered or whether I still talk about it. I can go faster if you've covered already a lot of this, but I do think it may be useful to see some. Okay.
I think it was covered enough.
Okay.
I mean, the CBAM. Did you get Mariana's presentation? Mariana Conte Grand yesterday, she talked extensively about CBAM.
Okay.
Daniela, what do you think about that? Do you think we can still touch upon and go in depth into the CBAM, or do you think that as far as the information we have is fine?
Nice to hear just views, and maybe we can change the velocity of the presentation.
Okay.
Yeah, I can, but that's useful then. So I can go faster, and perhaps I will touch on some points that may be different from what the other speakers spoke about. So this I will not touch upon. But the main point is that the EU, again, like with deforestation, the EU is very ambitious.
Como en la parte de deforestación, la Unión Europea es muy ambiciosa.
So now I am hearing myself in translation.
Me estoy
Bien, perfecto, Jus.
Is it okay? Good. So the EU is very ambitious on climate change. I've given you some dates, some targets. You must have heard about the reason why the EU wants to do CBAM, and I think it's very important to understand this. So the EU concern is that as the price of emissions in the EU is now reaching 18, 19 euros per ton of CO2, the risk of carbon leakage, that is of producers leaving the EU and producing steel cement outside of the EU and shipping it back to the EU, is large, right? And the CBAM is not to impose on Brazil, on Argentina, specific climate policies, but to make sure that the EU climate policies are effective. Okay, again, that's the EU view, that CBAM is needed to make the EU's own climate change law effective. Now, a side effect of this, and the EU is open about this, is that the CBAM will also push other countries to be more serious about decarbonization. And I'll mention it at the end. Since CBAM was announced, there's been a number of countries that have announced themselves that they will enact a carbon tax. Indonesia, Turkey, Vietnam. So that's a side effect. The other thing you have to realize, and it's very important, is that until now, the way Europe was dealing with energy-intensive industries was to say, you don't have to pay the carbon price for what you emit. We will give you free allowances. So the EU steel, cement, chemical industry, they didn't pay much yet so far in terms of carbon price. So they were not complaining about the emissions trading scheme, but what the EU is planning to do is to reduce the number of free allowances that these industries get and to replace that with CBAM. Okay, and I'll show you some numbers, but
Professor, if I may interrupt you at this point, if I'm not mistaken, a couple of years ago, you've written an article saying that border carbon adjustments mechanisms could be WTO compatible insofar as they reflect a domestic tax, if I'm not mistaken. But in this particular case, since they will continue to grant free allowances, isn't it sort of obvious that they will start imposing a tax on the imports while continue to grant free allowances? Isn't this, blatantly incompatible?
Yeah. So, and I'll show you the way it will work, but the plan is to gradually impose CBAM to the extent free allowances are pulled back. So there wouldn't be any situation where you get a free allowance and then your competitor would have to pay the price, the CBAM price. I'll show this in a graph in a moment. So, but you're absolutely right. You cannot have it both ways. Otherwise, it's not fair that the EU steel producer would get a free allowance and the Brazilian steel exporter will have to pay the full price. That would not be WTO consistent. Okay, because the bottom line is, and I don't want to talk about WTO compliance. As Veronica said, I'm one of the WTO appeal arbitrators. If ever Brazil challenges this to the WTO, this may become a case we'll have to look into. But I think it's common knowledge that it will be very important to do exactly what you were saying, namely that whatever pricing you enact, it's equivalent. It cannot be that the European producer doesn't pay anything and the Brazilian importer pays the full price. So you have to have a level playing field. It's very easy to say this, very difficult in practice to ensure this level playing field. This you may have seen already, but I keep confusing it in my own head. So once again, CBAM has been discussed for many years, but only since May is it for real. It's there now. It was published, it's in force, and it will apply as of the 1st of October this year. Now, between October and the end of 2025, if you're shipping steel from Brazil into the EU, the only thing you'll have to do is to report your carbon emissions. So the first time you will feel CBAM is by the end of January next year, where you'll have to file your first CBAM report. And this is only reporting. You won't have to pay. Okay. A few weeks ago, the EU issued an implementing regulation couple of 100 pages, very complex, just on the reporting. Honestly, CBAM and this deforestation thing, it will create a lot of jobs on both sides. And it will, create a lot of new jobs, a lot of accounting, a lot of experts will have to look into this. This will cost a lot. People will make careers out of it. Again, the question is, will it have a return on investment, right? So very importantly, you'll actually have to pay CBAM only as of 2026. So once again, we still have time to get the data to test calculations, but as of 2026, the actual payment obligation will be triggered. Since you have to report in the next quarter on the previous one, it's in May 2027 only that you'll have to submit your first CBAM declaration, and then we'll have to surrender actual CBAM certificates. So we still have time, but like with deforestation, perhaps even more so, this is really complicated. So you have to get your house in order, because otherwise you won't be able to ship your stuff to the EU. Now, the free allowances will be phased out fully only by 2034. So if you're a Brazilian steel exporter, it's only then that you'll have to pay the full CBAM price on all of your emissions. Before that, you'll only have to pay some of it, with an equivalent reduction to the free allowances that the EU producer is getting. And then, very ambitious, the EU goal is to cover all ETS sectors, so all products that are covered under the internal emissions trading scheme within the EU, to cover all of that with a border mechanism by 2030. So this will be a whole new tariff regime, but based on carbon emissions. And again, the products that are covered so far, not 7, but 6 this time: cement, iron and steel, aluminum, fertilizer, electricity, hydrogen. But it's a first phase. There were talks of covering plastics, basic chemicals, not covered yet. Same with refinery products. I see a hand up, please, Daniela.
Yes, regarding the phasing out and phasing in of the CBAM, the CBAM will apply to all the imports, but on a percentage of the total value? Is that it? Okay.
Yeah. So I thought this was a good slide to kind of visualize this, and it also goes to the earlier question. So as I said, as of 2026, you'll have to start paying. But it will only be a small, tiny fraction, because EU producers are still getting almost all of their allowances for free. And year by year, this will go up. And it's only in 2034 that you'll have to pay the full price. And the percentage here refers to the percentage of, the CO2 tons of emission. So the economic impact will be very gradual. But the calculation, the paperwork, the data, that will be triggered already beforehand. So that will be very difficult, maybe very costly.
If I may, I have another question, taking advantage of your expertise, of your WTO expertise. CBAM will be another tax on the border, according to the carbon content of the product. So if you add that tax to the custom duty of the EU, if you add both, and if it is above the bound tariff, the bound WTO tariff, that would be WTO consistent, or we will have a problem there?
Yeah, I mean, it's a very good question, very, very, very pertinent observation. I guess the way the EU would answer your question is to say that CBAM is not a tariff, it's not a customs duty. It's just the equivalent of an internal tax, the equivalent of an internal cost. So they would compare it not to a tariff or import duty, but to a value-added tax, a carbon tax. And as you know, they would say it's not the WTO discipline on tariffs, which is Article 2 that applies. It's the WTO discipline on national treatment, which is Article 3 that applies, and which imposes a strict obligation of equivalence. Yes, you can impose the tax on imports. I mean, if you ship alcohol or cigarettes into the EU, you have to pay the VAT. That's perfectly fine. No one will add the VAT, the value added tax, to your tariff binding. They will say VAT is one thing, tariff binding is a different thing, but you have to make sure that the VAT that Brazilian cigarettes will have to pay is the same, not more than the VAT that European cigarette producers pay. But your question is a very valid one, because it's still unclear how this is so new, this carbon price, carbon tax, that no one really knows, is this now a tariff, a customs duty, is it a tax, is it a regulation? It's something new.
Thank you.
Okay, so I've spoken about the timeline, the products covered. Again, to get a sense of what would be covered, if you look at the universe of free allowances that the EU is now providing, what is covered under CBAM is only a fraction of the free allowances. For some, the free allowances would continue, but for CBAM, you would have this phased out. And you can see that the biggest chunk is iron and steel and cement. But actually going to the real, if you ask me, the underlying reason why the EU is doing all of this is very much a financial one. As you know, like most governments, the EU has serious budget problems after COVID with the Green Deal. So CBAM and the ending of free allowances will bring a lot of money into the EU budget. So one calculation that I have here on the bottom of the slide is phasing out the free allowances for products covered by CBAM. This will bring in close to 20 billion euros per year, because the calculation here is based on an allowance at 60 euros per ton. Today it's closer to 90 euros. Okay, so a lot of money will come in on the domestic side. EU steel, EU cement producers will now have to pay for their emissions. But on top of that, CBAM will also impose a tax on imports of steel, cement, and one estimate, by 2040, of course, by then we'll have a lot covered, full coverage. This could bring into the EU coffers 80 billion per year. It's a lot of money, right? Of course, the hope is that that number will go down as the economy becomes greener, but whatever the EU Commission may tell you, one big benefit of CBAM for the EU is budget, money coming into the coffers of the EU. And this makes me think of the question someone of you had on deforestation. At this moment, the plan is that all of this money will just go to the EU budget, and it will be for the EU to decide what to do with this. So this money is not earmarked for climate change action, or this money is not going to go to third countries to help them cut emissions. Some of it may, and I think the EU will do some of this, has massive financing and the UN and what have you, but they haven't tied their hands yet to say this 80 billion will necessarily go to third countries to help them cut emissions. So this again will be a huge topic for discussion as CBAM is rolled out. What will happen with the money? So that I've covered. I'm sure you've looked at this as well. Now it gets too technical perhaps, but the plan is to cover not only direct emissions. If you take a ton of steel, basically calculating the production of CO2 that was involved in producing the steel, including cooling, heating. But direct emissions, as the EU defines it, doesn't include transport. Now, the idea is to also include indirect emissions, which is basically the emissions that occurred from generating the electricity you may need to make the steel. Okay? And that, at the moment, it will depend on the good. Annex 1 goods, you'll have to pay for both direct and indirect. Annex 2 goods only for direct emissions. But again, as the product scope will expand, they will also cover not just direct emissions, but also indirect emissions. Now, I was asking myself, which countries will be affected here? And that's just one study. So clearly CBAM, as it now covers 6 products only, it will hit mainly iron and steel imports, right? Brazil by far is the country biggest affected from Latin America, and it's mainly Brazilian steel, a bit of cement as well, but Brazil will be heavily hit by the CBAM. I'd be curious to hear from people from Argentina, other countries, what products are of concern to them, but it seems to me for Brazil it's mainly iron and steel. Any questions on this or comments? I don't know whether CBAM is a big issue for Argentina.
No, not yet. Yesterday, I think it was yesterday, no, when we heard about a study saying that it was quite small, the impact of CBAM on Latin American export in general, no?
Yeah.
Brazil, of course, will be the most affected, but for us, or for the big majority, I think the deforestation rules is more dangerous at this time.
Yeah. So just a little bit more on the mechanics of how this will work. So you won't get your steel, your cement into the EU unless you have an authorized CBAM declarant. And this will be the entity that imports from the EU the steel, or the entity that is your customs representative. So as with deforestation, this will be implemented at the customs level, right? This declarant will have to make annual declarations, so on a yearly basis, of embedded emissions, and there'll be verifiers, I think the accounting firms, whatever, that will have to check your annual declaration. Now, very importantly, for direct emissions, what the EU is looking for is actual data, installation, firm, plant level data of how many tons of CO2 were emitted making the steel in Brazil. The actual emissions, which will then be verified. But of course, from some countries, it may not be possible to get the data. And in that situation, the EU is ready to use default values. Default values means I don't have the data from my specific plant, but the EU will then do its own calculation. And the basic principle is that they will then take the average emission intensity of steel that is produced in Brazil. And they'll add a markup to that. So to put it bluntly, if you're a very dirty Brazilian steel producer, you may have an incentive to say, I can't find the data, and just fall back on the average emission intensity of steel in Brazil. Now, if this average cannot be found, then the EU has another fallback, and then they would use the average emission intensity of, and the percentage is not yet fixed, the 10, 15, 5% worst performing EU steel installations. So you can imagine these details will be highly important, because that goes to the question of for how many tons of CO2 will you actually have to pay? Okay. And then for indirect emissions, electricity, the rules are even more complicated. The EU will use default values, but you can opt to actually show the actual emissions linked to your electricity or indirect emissions. Now, once you have made your declaration, I don't know, I imported 10 tons of steel in the past year from Brazil, and 10 tons of CO2 were emitted making that steel. Then you'll have to buy 10 CBAM certificates and surrender them when you make your declaration, again, on a yearly basis. Now, these certificates, you can buy them any time of the year, and they will be priced at the weekly average of EU ETS allowances, EU emissions trading allowances, which is the price that EU steel producers have to pay per ton of CO2. Now, these EU allowances are auctioned almost on a daily basis. For CBAM certificates, they will use the weekly price. So I'm sure there'll be a lot of arbitrage. As the price may go up and down, you can speculate a bit and buy your certificates early on, or when they are priced lowly, and then surrender them later when they may be more expensive. Now, very importantly, for internal EU steel producers, the system is a cap and trade. So there's an overall cap on the number of ETS allowances available. And this cap will go down, which will mean that the price of allowances over time will go up. There is no such cap on CBAM certificates. So you can import as much steel as you want, as long as you pay the allowance price for it, which is very important. And if you have too many CBAM certificates, you can surrender them, you can sell them, but it's not a trading scheme like the EU ETS. You can buy them during the year, you surrender them. If you have leftovers, you can sell them back. Is this clear? This is a very dense slide, but those are really the very important details as to who will determine the CO2, the carbon content of your steel, and what will be the price that you'll have to pay per ton of carbon. Now, to me, this is kind of a scary slide. It shows the price. So now we are at, as I said, around 80, 90 euros per ton. By 2032, full price, no more free allowances. But over time, and that's the whole point of an ETS, over time, the price will go up to 240 and more euros per ton of CO2. So we are talking very serious carbon taxes in the EU, but also on imports. And this is the slide where I got the 80 billion number from. This is the revenue over time that the EU will collect from CBAM. So by 2040, estimates are that this would amount to 80 billion a year. Okay, now let me say a few words on exemptions and reductions. This goes to a deforestation question that was asked. Will developing countries have to pay the full price? Are they subject to the same requirements, notwithstanding common and differentiated responsibility principles? So in deforestation, we didn't have any exemptions for developing countries. There were softer rules, remember, for SMEs. With CBAM, it's pretty similar. So what is covered is goods that are imported into the EU. The first bullet point here is something that a lot of EU industries are very worried about. It's only when you actually import the steel or the cement that you'll have to pay. So if you use, say, Brazilian steel in Germany to make a car, and then you export the car, you will never actually have imported the Brazilian steel, so you won't have to pay the CBAM. which of course, if you're an EU steel producer, this is very problematic. Because if Volkswagen buys German steel, they'll have to pay the carbon tax for the steel. If they use Brazilian steel and they export the car, they won't have to pay anything. To me, that's a big loophole. But it may well be that the EU will fill this loophole soon. Now, more importantly, well, that's another detail. Offshore installations are also covered, because you had other clever traders that were using steel in offshore wind parks or what have you. So that's covered. There is no exemption for developing countries, not even for least developed countries. The only exemption or credit that the EU will give is if in Brazil or in Vietnam or in China or in Canada or in the US, you have a carbon price of your own. So if the steel is already covered under the EU ETS or a system linked to the EU ETS, I'm sitting here in Switzerland. Switzerland is linked to the EU ETS, so Swiss steel won't have to pay. And there'll be a reduction to the extent you can show that you already paid a carbon price in Brazil or in Vietnam. But very importantly, there's only a reduction for a carbon price. You cannot say, well, in Brazil, we work on lowering emissions through a regulation or through planting forests. For that, you won't get any reduction. You have to show an actual carbon tax, a carbon price in Brazil before you'll get a reduction. And that is a very controversial part of CBAM. Very controversial. The US, for example, is saying, sure, we don't have a carbon price in the US, but we have a lot of climate-related regulations that also impose a cost on firms. And the EU doesn't recognize that cost. You have to have an explicit carbon price. No equivalent regulation is taken into account. And then there's an exception if I don't know, if there would be a natural disaster in Brazil, there's exceptional situations where you can be exempted from CBAM. So there's very few exemptions, very difficult to get a reduction. At the moment, there's only a handful of countries that have a carbon price: China, Korea, some states in the US. But even then, their carbon price is much lower, $20, $29, much lower than the EU carbon price. So even those countries, South Korea, they'd see a reduction of close to $20 from the EU price, but the remaining 60 or 70, they would still have to pay. Okay, so a massive problem will be this study of equivalence between regulations, carbon prices. The OECD is doing a lot of work on this. So yeah, I won't go through this. This is what just came out. It's very technical reporting, what method you can use, have to use. Enforcement. Unlike the deforestation regulation, enforcement of CBAM is done more at the EU Commission level. It's the EU Commission that will have responsibility over the CBAM registry, over CBAM declarations, but it's still EU member states, France, Belgium, Germany, that will have to authorize declarants, that will have to sell the certificates, that will collect the money, and then of course that money will go to the EU budget. So there's still a role for EU member states, but more centralization at the EU Commission level than the deforestation regulation. There'll be verifiers, very serious penalties when you cheat or when you don't declare enough or when you don't pay for what you declare. Again, like the deforestation regulation, this is not corporate social responsibility. This is real, those are real legally binding obligations and sums you'll have to pay. Again, another reality check. So I checked Brazil in terms of dollars. There's a lot of dollar amount. But then if you look at, the percentage of your trade that would be affected, it's very low. as I said, mainly steel. The shocking example is Mozambique. I didn't know, but almost all of their trade into the EU is aluminum. So for Mozambique, almost all of their exports will be heavily hit. But again, you may be a small developing country, you have to pay the full price. That's the current EU approach. So looking at China, again, not to be exaggerated, it's a very small part of Chinese exports into the EU. If you look at the net CBAM cost for operators, foreign operators, this goes to the question of, well, what segment of the CBAM cost will you be able to shift forward to consumers? According to this study, quite a bit. And as much as CBAM may bring billions of euros into the EU budget, very likely a lot of that money will be shifting forward to EU consumers. So EU consumers will most likely have to pay much higher prices for any of the products we were talking about. So that, again, that's the open question of how much of the cost imposed by deforestation, by CBAM, will firms have to carry, as opposed to being able to shift forward that cost to EU consumers. Okay. Now, I'm almost done because I know we have a commentator. What about other countries? These unilateral measures, responses to the EU? I've mentioned it already. The US, for example, has a very different approach, a very different Green Deal. The EU has focused on cap and trade, CBAM now. Of course, the EU also has a lot of subsidies. Don't be fooled. What the US has done, and compared to other administrations, this is major progress. The US hasn't enacted a carbon tax, nor has it focused on regulation so much, but through the Inflation Reduction Act has focused on green subsidies. Okay, and it goes back to sovereign choices that countries make in terms of how they tackle climate change. And here the EU, as I mentioned, they are imposing not only the EU equivalent onto imports, but they are also imposing their mechanism of dealing with climate change, which is having a carbon price. And I think that's upsetting a lot of countries. Brazil may go with planting forests or reducing deforestation. The US may go with green subsidies. And the challenge is, could we find some kind of equivalence so that we can calculate the price equivalent of a regulation or a subsidy, so that that could be reduced from the CBAM that the EU is imposing. Now, another mechanism, because steel is so important for Brazil, is ongoing negotiations between the EU and the US on basically a climate club for steel. As you may remember, the US has imposed under the Trump administration 25% tariffs on steel. What the Biden administration, with the help of the EU, is trying to do now is to keep the tariffs in place, but call it a carbon tax, or not so much a national security one, but something to ensure the sustainability of steel, so that you would not have to pay it if you join this global arrangement, under which you'd have to commit to reduce the carbon intensity of your steel production. This is ongoing, but that may be a way for the US steel industry to get away from CBAM under this global arrangement on sustainable steel and aluminum. And to be honest, that may be a route also for Brazilian steel producers to avoid CBAM by joining this global arrangement. Now, I've mentioned it already, Vietnam, Turkey, Indonesia have introduced their own carbon price mechanisms pushed by CBAM. Talking of EU deforestation, as I've mentioned, I've been talking a little bit to some Brazilian interests, and one kind of shocking, interesting idea would be, for Brazil to impose not its own CBAM. They could. India is talking of one, but for Brazil to do something on deforestation, but not going back to 2020, but going back 200 years, and to actually impose a limitation on EU imports based on what may have happened in Europe in terms of CO2 or deforestation. Again, in terms of fairness, those are mechanisms that may look a bit outrageous at first, but if you follow the logic of the EU, it may be not so far-fetched. India as well is very upset, very concerned about CBAM. They've been thinking of certain responses. At first, they were very keen in May to challenge the CBAM before the WTO. Then they started negotiating with the EU, which I think in the current situation is probably a wiser decision, unless you're a party to the MPIA, this appeal mechanism at the WTO, because if India files a case against the EU at the WTO, there is no appellate body, so the EU could appeal into the void, so there's nothing that may happen. But Brazil, as an MPIA member, some other Latin American countries as well, to the point where India is now preparing its own carbon trading system and measures to basically avoid CBAM. Very interestingly, the major challenge to CBAM is not from a third country, but has been recently filed by Poland. So Poland, Hungary have been staunch opposers of the EU Green Deal, and Poland is challenging CBAM before the Court of Justice of the EU in Luxembourg. So that's also something to watch. So if I may, and then I'm happy, really keen to hear your questions, hear the commentator. Again, I'm not advocating the EU position. What I've tried to do is to explain what the EU is doing, and it's very different from what the EU was doing until recently. It's steaming ahead with a whole slew of unilateral environmental instruments. Another one that I didn't even talk about is the due diligence, human rights due diligence that the EU will impose on basically all companies that want to do business on the EU market. If I were a Brazilian, Argentinian exporter, I would be very worried. I would prepare very carefully, look into this in great detail, both EUDR and CBAM. One window of opportunity is that these measures will be effective only in a year and a half, 2 years. So the moment to act is now, to lobby the EU Commission, to make some of the arguments you've already been making. There's a lot of implementing acts, delegated acts that the EU will have to enact. So there's room to soften the blow of these measures. Other countries are enacting their own domestic measures, taking actions, perhaps considering a WTO challenge against the EU on these measures. And that's basically what I wanted to share with you. So some EU examples, reactions by other countries, and overall, just trying to press upon you how important these measures are, and how there's a very serious risk that your trade may be affected. So there's something to really work on. But I'm not here to predict doomsday or complete shutdown of trade. That there's a lot of windows, a lot of opportunities for you to push the EU to make changes. So I'll end on that note. Thank you.
Muchas gracias, Just, por tu presentación. Tenemos una pregunta, pero me parece que quizá podríamos
Thank you,
darle la
Just, for
palabra
your
al comisionista y
presentation.
luego
There is a
continuar
question,
con
but
las
I think we
preguntas. ¿Te
could give the
parecería?
floor to Rodrigo, and then we can entertain questions if you
Entonces,
agree.
vamos a escuchar a Rodrigo Fagundes.
So we're
Es
going to
profesor
listen to
asistente
Rodrigo
en la Fundación Getulio
Fagundes,
Vargas, en la Escuela de Relaciones Internacionales,
who comes
coordinador
from
del
the
Grupo de
Getulio
Investigación en
Vargas
Comercio y Desarrollo Sostenible,
School,
investigador
who's involved in
principal
sustainable
de proyectos de
development. He's the
transposiciones
main
políticas de
researcher.
las empresas sobre el comercio y doctor en Relaciones Internacionales y
He's a
Ciencias Políticas
PhD
en el Instituto
in
de
International
Graduados de
Relations,
Ginebra.
Political Science at the
Adelante, por
Graduate
favor,
Institute
Rodrigo.
of Geneva. He's done research in trade and sustainable development. Thank you very much for the
invitation. As most of the people in the audience are from Brazil, I'm going to make my comments in Portuguese. First, as I said, I would like to thank the invitation by IDB and Veronica. I'm so happy. This is an honor to speak about this relatively new notion, which is so sensitive to Mercosur countries. I want to thank Just. He is an excellent researcher, and I did my PhD with a friend of his, and I know his work very much. So thank you again, Just, for your support. I'm going to make some comments on CBAM as a whole and the presentation made by Just. Just presented a vision which is aligned, not aligned, but based upon what is going on in Belgium. He is from Belgium, and it is not disconnected from the reason, the rationale I'm going to present, and which was reflected in my own work. There are two significant things related to CBAM. There's a question of legality and legitimacy. In terms of legality, the EU maintain its own position, and they know how to draft bills which are not going to be questioned. So they are strong at drafting documents. So they have learned as traders to draft regulation which is not going to be objected. But there are certain key elements that we have to focus on to see how the European Union learned to draft that legislation, which may result in international questioning. This started, for example, in tuna fishing in the past, which also encompassed dolphins in the Pacific. And there was a complaint against the states. And when Just speaks about unilateralism is not the same as illegality, that's a very significant point, because from the legal structure, you may fall into the temptation to think that this is illegal. But before, I want to speak about legality. As Just said at the end of his presentation, there is a movement which is extremely strong to object or to challenge some of the aspects of legal aspects of those regulations which are autonomous or unilateral in the EU. Indonesia, for example, started a dispute against the EU dealing with the guideline of renewable energy. There are some products which come from the EU related to the productive line of biofuel, ethanol, and sugar. And you must have a specific measure to get into Europe. You don't take into account the specific questions of developing countries. So Europeans are going against certain articles in the WTO. And I would like to 593. That is what Indonesia presented, and I'm going to say it in English.
In the preparation and application of the technical regulations and conformity assessment procedures at issue, circumstances specific to the developing countries where palm oil and oil palm crop-based biofuel are produced, the European Union appears to have failed to ensure that those measures do not create unnecessary obstacles to exports from developing country. And this could be in violation of Articles 12.1 and 12.3 of the TBT
This could
agreement.
be.
So the issue here is that perdão, vou voltar para o português. A questão aqui é que
The question here,
nós estamos falando de algo novo.
we're speaking about something new, as Just presented.
E aqui eu quero abusar da boa vontade.
And I want to abuse his good willing because he is connected to the WTO. And I would like to ask Just, what's the vision, what's his own vision as an operator, legal operator, vis-a-vis the possibility of Indonesia to win something or to reach a partially favorable decision defending the articles of I've just read in English. So, because the European Union does not take into account the specific conditions or features of developing countries. Is there a point you can raise in terms of legality in the EU? Do you think the EU may get rid of those accusations fast? What is your vision used as a legal operator in this regard? That in terms of legality.
I'm speaking as a political scientist, and winning and power asymmetries, we are at a point where Brazil and the Mercosur have a low room for negotiation because the EU has a unilateral point of view and global point of view that can disseminate its rules. So when we say this is unfair, the EU negotiators are thinking, yes, that's the case, and what shall we do about it? Because they have a political and negotiation clout to say that unilateral rules are important for the EU and will be imposed in any way, whether we like it or not. So, from a perspective of the negotiation, we need to find a point to say, this is not the situation. You need to take the monies collected through the CBAM and invest in the Amazonia, for instance, because morally you will be compelled to do so, and you will have to deal with that problem in the Amazonia. That is the first point for Just. The second question about legitimacy is also important. What's the problem when we speak about unilateral rules? In terms of sustainability, I mean. They might not be necessarily applied. What do I mean by this? These rules are focused in environmental matters. They can have negative spillovers for other sustainable development areas, such as local socioeconomic developments. There are people acting in Brazil about this. This was verified through a study in my institute. We analyzed the impact of biofuel EU regulations on SMEs in Brazilian municipalities. And we found that is an imposition of fuel exports to the EU, and this does not create positive impacts on sustainable development areas. Aside from the environmental topic, they do not contribute to SMEs empowerment and equal opportunities for people. We are speaking about sustainable development, and in truth, it is not sustainable at all. It's environmental protection that can create spillovers in the sociocultural arena. Why are we speaking about this? dealing with environmental requirements, it's about a capacity. If you are big and you have money, you will be able to do it. And if you are not a big player and you don't have any money, you won't be able to do it. No matter, regardless of the fact that you have some elements to help your local SMEs. So we see big producers, big farmers that are close to this big Cargill trader who deals with agricultural products. They want to expand, and in these places, there are also SMEs that cannot comply with EU rules. So they don't have negotiation clout. So their products are more expensive, so they are going to start having to sell their own lands because they cannot make their products economically viable. So this leads to land concentration, and Brazil has a problem with land concentration. So how are we going to create unilateral rules that are focused on sustainable development, and not only to respond to environmental topics that are relevant to the EU? Another topic that should be discussed, the more complex the rule implementation process is, the more capacity you have to deal with this. In CBAM or the EU guidelines, most of these regulations have been created by private certified, such as Bansud, that acts in Brazil in the sugarcane production chain. If these private agents can work legitimately and reliably from the impact analysis point of view, because these actors lobbied in the EU to get their certificates. These are some of the problems we face in terms of legitimacy. So I want to hear you or some other colleagues if they have any other comments about legitimacy or legality, but specifically in terms of just positioning. How is legality with the dispute 195 between Indonesia and the EU? These are my comments. I'm open to any question that you might have.
Muchísimas gracias, Rodrigo.
Thank you, Rodrigo.
Damos la palabra, Just.
Just, you have the floor. If you want to
Thank
come
you.
in here.
Yeah, thank you, Veronica, and thank you, Rodrigo. Amazing to, I'm not sure we've met in person, but probably we must have if you've done your doctorate here, but so happy to see our alumni take on these important positions. You make very valid points, right? So on legality, I've mentioned that I'm a WTO arbitrator. I think certainly a country like Brazil, the system still works. The MPIA is there. I think countries should challenge some of these aspects of CBAM deforestation. The EU is expecting it. The EU, to be honest, I really think the EU would listen if the WTO were to say this or that is inconsistent. I don't think the EU has reached the point that, if you ask me, the US has reached, where the US doesn't even think anymore about WTO compliance. They just enact legislation, and the fact of WTO compliance doesn't really go high on their agenda. So I think legality still matters a great deal in the EU. and if the EU were to be condemned on aspects of this, I'm pretty sure that they would adjust the regulation. That's also what the regulation says. It has to be WTO compliant. Now, as to your question of whether the RED II, which is the EU legislation challenged by Indonesia, whether that is in compliance with WTO rules. Just for the people in the audience who don't know the details of this case, it concerns palm oil, and what the EU is doing is it has targets for biofuels, and it provides subsidies, or it provides certain percentages that EU member states have to reach in terms of biofuels. And at first, the EU was very positive about palm oil until they realized the indirect land use issues, environmental, social issues. So they have classified palm oil as high risk. It's a little bit similar to the risk classifications they will have of countries under the Deforestation Regulation. So under RED II, this EU regulation, Indonesia, Malaysia, they can still export palm oil, and they still do in huge quantities, but it will no longer count as a biofuel. It will no longer count towards the targets that EU member states have in terms of reaching certain percentages of biofuels or renewable energy. Remember, with deforestation, if you don't meet the requirements, your palm oil, your soy is out of the market. With this case, it just, your palm oil doesn't count as biofuel. So the intervention is less serious, but I think Rodrigo is exactly right that case, and it's expected to come out, the panel report is expected to come out any time now this year, will tell us a lot about how CBAM, or the Deforestation Regulation, fits under WTO rules. I mean, of course, it's just one panel who can say something on RED II, but it will be, potentially, it could be a very important precedent. And for me, it's hard to predict what the panel would do. It's a very technical legal issue, but Rodrigo is completely correct that we should watch that case to see how CBAM, Deforestation Regulation, could fare under WTO rules. Now, an equally valid point, and perhaps more valid, is the question of fairness, legitimacy. I mean, something may be legal, but still unfair or not legitimate. And the question of where the money should go to, it was already raised in questions. I think it's a very legitimate one. If you're going to impose this on countries that haven't developed yet to the same extent as Europe, should the EU not help them or make some mechanism whereby you refund, right? Here in Switzerland, we have a carbon tax on domestic fuel, and everyone pays it, even poor people. But then much of the revenue of that carbon tax is given back to people through a reduction in our health insurance premiums, which of course predominantly benefits poorer people. So I think the question of what will happen with the collected funds, I don't think from a legal perspective it may be all that important, but from a fairness perspective it will be very important. And then you make another important point, no, which is Switzerland, Singapore, Argentina, small markets, they cannot enact these unilateral instruments. It will be very difficult for them, because other countries may stop exporting to your country, or you may not make much of a difference. If you have a huge market like the EU, but also the US, China, Brazil, you have market power. This is not something you choose. You have that market power. And it means you can do more things. And it's a reality. You're absolutely right. But it reminds me a bit of the Spider-Man saying, no, with a lot of power comes a lot of responsibility. Yeah. And that's how the EU looks at it. we are consuming so much, and indirectly we contribute to deforestation, to climate change. We have to do something about this. And perhaps they are right to feel guilty, but then the devil is in the details as to how you level the playing field, how you impose deforestation requirements, what you do also with the CBAM monies. But it's a very good point that unilateral measures, they can actually trigger agreements, collective action, but the political reality is that they are only available to big players, right? It's not so much even developing countries, it's small countries like Switzerland and big markets like the EU, the US, China, Brazil. But it's good to distinguish legality from fairness, absolutely. I see some hands up. I'd be very curious to hear what other people think.
Marcio, sí, ahí vemos una mano levantada. Marcio hizo una consulta en el chat.
Marcio wrote a comment on the chat box.
Oralmente.
Can you read it out, Marcio, please?
Sim, posso. Boa tarde a todos. Excelente a apresentação, professor Paulinho.
The presentation has been excellent. I'd like to ask a question related to CBAM, considering that the reason why the CBAM was created is to avoid carbon leakage. Wouldn't it be more coherent or consistent that the measure try to equal carbon emissions allowed by the EU in the European carbon market? For instance, carbon emissions embedded in products imported by the EU could be mitigated in some other carbon market, for instance, of the exporting country, where the value of the carbon ton has been lower than the value of the carbon ton in force in the carbon market. So I think we would be on an equal footing in terms of emissions. Emissions would be equaled, but the price of the payment for those emissions would be different. So, considering that there was an equivalence here in carbon emissions, wouldn't legality be missing to impose CBAM? Because at the end of the day, the emissions would be the same. What would have been there is a price difference between the carbon price in force in the exporting country and the carbon price in force in the EU. In that way, wouldn't it be excessive in relation to the environmental goals that created the CBAM, considering the carbon leakage?
Okay, yeah, very good question. So I think you raise a very important point as to the multiple objectives behind CBAM. And I think the Commission itself is struggling a bit with these different objectives. You have the argument of carbon leakage, which is the main argument. But you're correct, if carbon leakage is the concern, why impose the same price on imports, right? Because if you impose the same price on imports, your objective is one of equalization, leveling of the playing field. If it's really carbon leakage, you may want to look at whether there will be carbon leakage, and that may depend product by product. So they say it's carbon leakage, but then they don't really look or take that into account in their calculation of the tons of carbon you'll have to pay for, and certainly not the price, right? So based on what they actually do, I think you're right that the de facto objective is one of leveling of the playing field. A bit like a VAT that I mentioned. The VAT in Belgium is 21%. Stuff imported from Brazil, you may get a rebate in Brazil for the VAT. I don't know whether Brazil has a VAT or a sales tax, but then you'll have to pay the 21% VAT if you ship to Belgium. So what CBAM is, it's, again, a value-added tax, but this time based on carbon. The third objective that I think is implied in CBAM is pushing other countries to enact carbon policies. But then again, that's not really taken into account when you calculate the price, because it's only price measures that are deducted from the European CBAM. Otherwise, you pay the full price. So there is a mismatch a little bit between the objectives and then the actual measure at play. And the question is whether this will have an impact on the legality. But I think where the legality will come into play is on the issues that you've mentioned, the calculation, the number of certificates you'll have to submit, and then the pricing and the absence or existence of certain reductions. But you're right, if you look at the details, this is not about carbon leakage, it's about equalization. I see another hand, Pedro. I don't know, Veronica, whether you want to...
Just very shortly, and here also as a Graduate Institute alumni, one short comment and a question regarding the EU deforestation rule. On the issue of fairness that you were touching upon, although there is a provision of granting support for producers in local countries, so far the only thing we've seen is a project named Amazon Plus, which is maybe well intended, but it only serves those countries who do not have the wherewithal and technology to actually monitor a deforestation and forest fires in their country. For countries such as Brazil, where we have many of the technicians who are operating the EU Copernicus project, they were trained here by our experts. We have a lot more experience than the EU on this. It is not about bragging, but we have the largest tropical forest. This is something we should naturally have more experience and more advanced technology, and we do. So it's in this issue of fairness. It's adding insult to injury. We see that so far what they're putting on the table in terms of support. It's something that for the main victim, as you yourself has labeled, it doesn't help us at all. And my question would be, touching slightly upon the legality issue, I believe that in a case, it would probably boil down to, judging the chapeau of Article 20. We would see whether the same effect could have been achieved through a less trade restrictive measure. So in this case, since preferential market access would be a legally WTO compatible option, it could be done through GSP plus, for instance. I would like to hear your thoughts on this, because in my opinion, people, several people in the Brazilian government I've spoken to, this is something that we should be. This is an argument. They could be. Support, if you have a preferential tariff for, say, a cocoa, beef, and so on, you would naturally converge and push all the producers towards all the producers that are exporting for the EU market towards sustainable patterns. I'd like to hear your thoughts on this. Thank you very much.
Yeah, very good points. It's a fantastic point in terms of technology. You don't need this, you need the cash to actually, that's very interesting. On the legality, it will be tricky, right? So one thing where the EU again was very clever is to impose the measure equally on EU products as it imposes it on imports. So the relevant GATT provision will most likely be Article 3 of GATT, which again raises the question of, is the EU favoring domestic products over imports, which may not be easy to show, given that the same rules apply to both. But if you can somehow show it, and I think with the historical element that I've mentioned, or perhaps the lack of production in the EU of many of these products, there may be a de facto discrimination, in which case, as you said, Pedro, you need to justify it as an environmental measure. And under the paragraph 20G, is this a legitimate environmental measure? There may be less trade restrictive alternatives, right? The case law is pretty flexible on this, actually, mainly because of a case that Brazil largely won, Brazil tires. Brazil had a ban on retreaded tires, and the EU in that case was saying, no, you can deal with dengue fever, fires in tires in different ways. You don't have to ban it. And the panel, the appellate body said, no, to the extent if it's contributing a bit, it's good enough. And alternatives of better management of tires, waste management wasn't found to be sufficient. So it's possible, but you'd have to show a different way of dealing with the problem of deforestation that would achieve the same result. Remember, 111,000 hectares of forest saved, perhaps with a different mechanism, could be GSP plus, could be, I don't know, anything else that is less trade restrictive. But yeah, you're right, that would be one of the avenues you could think of. I think the other one is under the chapeau that you've mentioned, that you cannot discriminate between countries that are similarly situated. And I think if Brazil were classified as a high-risk country, you can make arguments that, look, deforestation has gone down in Brazil, we are very serious about it. Why are we high risk and, I don't know, Argentina not? So that could be a discrimination. Or Belgium not, right? And the other thing there, I think it will be important to push the EU to not classify Brazil as a whole as high risk. There may be high risk in some Brazilian states, but perhaps less in other Brazilian states. But all of these details will have to be worked out. But in terms of the legality of this, it will be one of national treatment discrimination and then environmental exceptions along the lines that you've mentioned.
Gracias, Just.
Thank you, Just.
Estamos un poco sobre la hora, pero si hay alguna otra pregunta.
We're a bit behind schedule now. If there are any other questions, it will be welcome.
Bueno, te agradecemos mucho.
Okay,
Just,
thank you, Just. Thank you, Rodrigo, for your. I would like to present my compliments to all the presenters, Ana Vasco, who's the head of INTAL, and I would like to thank all the people who attended the course, Professor Just for his marvelous presentation. I want to thank Daniela Matos as a coordinator and the director from CSEX, Ana Dagasso. And I would like to thank all my colleagues from IDB INTAL, and especially Veronica for the organization of the workshops, and all the experts from different countries I'd like to thank for their generosity. To me, it's a great satisfaction to participate together with the experts. The 5 sessions, there was an interface between trade and environmental development with different points of view, national and international and regional, different aspects, legal, economic, environmental, social aspects. The debates were inspiring, and they are going to be good input for our policymaking. I would like to thank also the number of participants. We had 102 participants in total. Most of them are Brazilian, represented by different ministries, the legislature, and 22 colleagues from Argentina, Paraguay, and Uruguay. So it's a source of happiness to see that the participants were committed to the discussions and committed to analyzing the situation. This participation reflects the significance of this topic and also the concern vis-à-vis the implementation of new regulations dealing with deforestation and carbon in Europe. To conclude, I would like to make reference to the topics which will be covered by the ad hoc group. The debates in this workshop are going to be food for thought in the future. Thank you very much. Thank you, Elisa. We're going to give the floor to Ricardo Rosenberg, who's a senior economist of INTAL. Ricardo, you have the floor. Thank you, Veronica. Thank you, Elisa, for your kind words. Of course, I want to thank Just and Rodrigo for their excellent presentations. And on their behalf, I would like to thank all the speakers and experts who participated in this workshop. We may say that this workshop was characterized by 3 features. First, the excellence of its speakers. That was the common denominator, the high-level discussions. In the second place, this mix of voices, this chorus of specialists like Just and representatives of international bodies such as the WTO, the World Bank, and IDB. And also voices represented in Latin America, voices from Brazil and Argentina. This gives us a global vision of the problems at hand and with special focus on our region. And third, integrality. So usually these topics are watertight compartments, and the great contribution of this course is to put together trade and the environment, which is so significant at international arenas. Let me thank all the officials of all the countries. First, those coming from Brazil. I would like to stress the opening of Brazil because they wanted all the countries from Mercosur to participate. So Uruguay, Paraguay, and Argentina were able to access the workshop and participate. And this is something we should stress. To conclude, this communion in this community shows that trade and environment is one of the main topics in the region. It's not a Brazilian problem. It's not an Argentinian, Paraguayan, or Uruguayan problem. It's a global problem, not only because it affects the interests of different businesses, but also it involves international trade with new challenges and needs for adaptation to climate change. I think the agenda was very good, and I think we have to go deeper and tackle the questions that crop up, not only from the theoretical point of view, but also the requirements, the selection criteria applied to trade, which are going to be applied to different countries. That's why I believe that this is a first step to go deep into this area. I would like to thank Elisa and Ms. Praceres, together with Fabricio Perti and Pablo Garcia. And I would like to thank all the people from MEDIC and CSEX, Daniela Matos, and our colleagues, because of their participation in the contents of this workshop. And I would like to mention Nathalie Tiva from the IDB, who's following up the developments in Brazil, who is a golden link between Brazil and the IDB. And Veronica, who's been the factotum. And I would like to thank the interpreters, the technical people who make this virtual meeting possible and makes things easier for all those coming from different countries, from Latin America, from Europe, and which make all these dreams concrete. So we're looking forward to meeting you soon. All the material is going to be at your disposal. The material, the presentations. We know that we have to face a complex future, and Veronica, you have the floor if you want to say the final words. I would like to thank all of you. It's been a pleasure to organize this course with a high level of speakers.